Yes.
My lord, I beg to mention one unlisted item.
Unlisted?
Yes, my lord, for tomorrow, my lords.
Or
In
for
fact,
tomorrow.
yes, a bunch of analogous matters are listed tomorrow before court number 2, my lord. So if this can go to court number 2, my lords. It's a matter regarding the proceedings under the PMLA.
Mentioning is before the
Senior
bench.
Yes, my lord.
All right.
Obliged, my lord.
Yeah.
Please, Your Lordship.
With the consent of the other side, my lord, I beg to mention my lord, item number 11, my lord. Here, my lord, they have filed their affidavit in opposition, my lord, on 13th of August. I am praying for 2 weeks' time to file my reply, my lord.
You are for the petitioner?
Petitioner, my lord. I have taken the consent, my lord.
Okay. 11 on the request of Mr. R.S. Misra stands deferred to be listed after 2 weeks, enabling him to file the rejoinder.
My lord.
It is submitted that the counsel for the respondent has also been informed.
There is an interim order, my lord.
The interim orders, if any, stands extended till the next date of listing,
My lord.
a date after 2 weeks. Give a date after 2 weeks.
Much.
Yes.
May I please, Your Lordship?
Yes.
My Lord, item 3, my Lord, this matter may come on next Monday, my Lord. 3, I've taken consent the other side, my Lord. We have filed affidavit already, my Lord.
Yes. Who's appearing for 3, item 3? We are for item 3
Item 3, part 1 list, my lord.
for the petitioner.
Part
My
1.
lord.
Any objection to the prayer made?
No, my lord.
Okay. And item 3 on the request of Mr. S.K. Medi appearing for
One and two.
appearing as CGC.
Yes, my Lord. 1 and 2, yes, my Lord.
1 and 2 appearing for the respondents stands deferred to be listed next Monday. Counsel for the petitioner is present.
Highly appreciate.
My lord, item number 9. I respectfully request an adjournment in this matter as my senior counsel has another work, his personal work.
Item number
9.
9. Item 9, with the request made on behalf of the counsel, arguing counsel for the petitioner stands deferred to be listed, stands passed over for the day. Yes?
Lordship, if possible, I have consulted the matter with the senior counsel. I will be leaving, I will be absent for the next few days, so may the matter be taken up on the coming month, first week of
Item 9.
September.
Item 9.
Yes, Lordship.
You're for the respondent.
Yes, Lordship.
When do you want it? After 2 weeks.
Yes, Lordship, September first week.
Yes? All right?
Yes.
On joint request, matter stands deferred to be listed after 2 weeks. Registry will list the matter on a date to be fixed in the first week of September.
Obliged.
Daily list, item number 1.
May I please, Your Lordship?
Yes.
I am the humble counsel of this honorable court, but Your Lordship, here I am appearing in person, Your Lordship.
Okay.
Okay. If my Lord may kindly bear with me to page 15, Your Lordship.
1-5.
Yes, correct, my Lord.
Yes.
Paragraph 23, Your Lordship.
Paragraph?
23.
Yes.
Shall I read, my Lord?
You may.
The respondent number 1 and 2 froze the petitioner's account. Petitioner is me, my Lord. Prior to 14 February 2025 without any authority of law, and the account continues to remain frozen by virtue of the interim order dated 5/3/2025 and 28/1/2026 passed by the Senior Civil Judge College in CMA number 14 of 2025. Such blanket and indefinite freezing of the entire account without constituted a clear and egregious
By which
here
order is
on
the
violation
account
of
frozen? By which order? Where is the order?
by civil judge order, Your Lordship.
Can you refer to the page number?
Civil judge order is in
Well, page number 37, man.
37, Your Lordship.
37.
Page 37.
That was an interim order passed by the civil court, my lord. To be concise, my lord, if I'm allowed to take you to page 19, my lord.
19.
Page 19, my lord.
Yes.
Paragraph 30 to 32.
Yes. Yes.
I'll proceed, my lord. That the petitioner further begs to pray and submit that the continued freezing of his entire HDFC bank account is causing immense loss in irreparable injury to him, including but not limited to number A, inability to pay monthly and yearly premiums in respect of his mutual
Who's
fund.
appearing for HDFC?
Your Lordship.
Who's appearing for the bank?
Lordship, I'm appearing for the bank.
Yes.
For
Why,
one.
why have you frozen the account? Freeze the
Madam,
account?
because there was a direction from the Tamil Nadu government, my lord, the police from the Tamil Nadu, to freeze the account, which I have also, my lord, your Lordship will find at my written statement, my lord.
Page number?
Lordship.
Where is the communication of the police?
Yes,
Cyber,
madam. At
cyber
page number 80, my lord,
80.
starts from 79. If I may, my lord,
Yes.
submit, my lord.
Yes.
In this case, what happened, my lord, there's a series of litigation. My lord, the order which has been under challenge in this particular CRP, my lord, is at page 141, whereby he has been aggrieved by the order of the learned civil judge, where the matter has been kept pending because there was a writ petition filed before here before this honorable court, my lord. If your lordship may kindly come to page 141, my lord.
141. Yes.
And that is the order which has been challenged. This is the impugn order, my lord. If I may, my lord, at page case record put up on today, the present application filed by the applicant under order so and so, not to release any amount lying in the applicant's account bearing number so and so at HDFC bank account so and so, which was freezed by the opposite party without any lawful justification. Learned counsel for the applicant prays for disposal of the present pending application. However, the learned counsel for the applicant has filed WPC number so and so before this Honorable Gauhati High Court, Aizol bench. The Honorable Gauhati High Court passed an order dated 13/1/2026, in which the Honorable Gauhati High Court has stayed the operation of the order dated 3/3/25 passed by the learned Metropolitan Magistrate, the Hyderabad, Chennai, till the next date of hearing. Considering the order dated 31/2026, passed by the Honorable
Where
Gauhati
is
High
the
Court.
order of the High Court? Where is the order
My
of the
lord,
High Court?
This is the at page, my lord.
My lord, I have filed an additional
137.
affidavit, lordship, in that it is there, lordship.
You are representing whom?
I am the private respondent, lordship. Respondent number 4. The writ
Show us,
petition was dismissed, my lord.
writ petition was dismissed.
I have filed a writ appeal, lordship. What has happened in this case, lordship? There was a freezing order passed by the magistrate in Chennai. Now, the petitioner here in lordship, he has challenged the order of Chennai before the Gauhati High Court in Aizol, and there was a stay order passed. And then, lordship, I have challenged that same order in a writ appeal, lordship.
What is the status of the appeal?
Writ appeal is allowed, lordship. All the orders passed by the single bench has been quashed, and it was also directed that the writ petition which was pending should also be dismissed. Accordingly, lordship, the writ petition was also dismissed.
Right.
Now, in this in the civil revision petition, nothing remains, Lordship. He's just merely wasting the time of the court saying this, that things, Lordship. Lordship may kindly come to page number 141, Lordship. That is the impugn order in the writ petition, in the civil revision petition. Lordship has seen the impugn order, Lordship, in page number 141.
141.
That is the impugn order in the civil revision petition.
Yes.
The same order which my learned friend M. Smith was referring to.
So
The present application filed this writ petition, Lordship, civil revision in para number 3. The learned counsel for the applicant prays for disposal of the present pending application. However, the learned counsel for the applicant has filed WPC.
So this
WP
this appeal is pending. It's
no,
pending.
it dismissed. This writ petition is dismissed, Lordship.
No. The matter before the civil judge.
Or this is pending, Lordship. This is pending, and
This is
Lordship,
pending
he has
because-
only been agreed by the order, whereby a date has been, the Lordship operative portion of this order may be seen at para number 4. Considering the order passed by 13/1/2026, passed by the Honorable Gauhati High Court Aizawl bench, it would be appropriate for this court and also for proper adjudication of the present application to wait for the decision of the Honorable Gauhati High Court in WP Criminal 9 of 2025 before passing final orders on the pending injunction application.
Yes.
That is the impugn order. And this writ petition has been dismissed by this Honorable Court. So, Lordship, what I am praying, Lordship, instead of deliberating on irrelevant deliberations, Lordship may fix a date before the court in Kolasib. We will appear before the court and a hearing may be done and the injunction application may be heard. Madam, what has happened from 5/3/2025, an injunction is running against me. And the petitioner has been filing litigations after litigations which are dismissed by this Honorable Court. And then, Lordship, he is buying time and always taking dates after dates. Lordship, my money has been stopped, my lord, because of an injunction from 5/3/2025. And after that, Lordship, this civil revision petition, which is already infructuous, is pending. And so many dates has been taken in this case, Lordship.
You are for the private respondent,
I am for the private respondent, Lordship.
or
Respondent
rather
number
the
4.
appellant in writ appeal 1 of 2026.
I am that.
Yes,
Sir,
Mr. The petitioner in person, what do you say?
My respectful submission is that, my lord, in page 20, paragraph 31, may I continue, my lord?
Yes.
That the Honorable Supreme Court has repeatedly held that the expression life in Article 21 includes the rights to live with dignity, the right to livelihood, and the right to carry on one profession or trade in a meaningful manner.
Before this court, in the present proceedings, what is your challenge? You are challenging the order.
My lord,
You are challenging this order passed by the civil judge.
yes, my lord. There was a disputed amount and undisputed amount, my lord.
That's right. Now the
Disputed amount-
civil judge has ordered that this application shall await for the decision of the High Court in writ appeal criminal 9 of 25. This came to be disposed of or dismissed, and against which an appeal was filed. The appeal was allowed and the writ petition was dismissed.
Correct, my lord.
So
As
there is-
submitted by my
So there is no
Learned
restraint, there is no restraint for the civil court now to proceed in your matter.
Correct, my lord. That at that point, my lord, my respectful submission is that in respect of writ petition, that is a challenge of the disputed amount, my lord. That is the challenge of the order passed by magistrate, which was malifiedly prayed by the case IO. So that is in regard to disputed amount. As far as the disputed amount, the submissions of the learned friend, that is acceptable. But as far as undisputed amount, they have no locus standi to submit it because they have not engaged.
You are before this court challenging the order at page number 141. Yes?
Yes, correct.
This 141 contains a direction at para 4. If you read para 4, Your application is kept pending because of the writ petition criminal 9 of 25.
Correct.
Now that has
That-
been
all-
closed, and against which a writ appeal has been filed, writ appeal has been allowed. So there is no restraint for the civil judge senior division now to proceed in the application. So you go to the civil court, appear before the civil court, urge your case.
The-
We
There is
direct the, we
no
direct the
correct
parties to appear before the civil court on a fixed date and hear the
That
matter
is-
expeditiously.
That is one point, my lord. But
Yes.
the other issue is that the civil court has not considered the undisputed amount. That is why this petition has been filed.
No, civil
only a
courts,
direction was given-
from the order that you have challenged, civil court has not even considered any matter on the ground that this matter will be considered after disposal of the writ petition. That is the order. So, we permit, we direct, we relegate the matter to the civil court, you appear before the court, and we'll give you liberty to urge all matters before the civil court,
It's,
right? And the civil court will pass appropriate orders thereon. If you are agreed,
Wait,
you
please,
can
Your
still
Lordship.
come back to the High Court.
with
Wait,
respect
please,
to
Your Lordship.
Yes.
Well, in fact, the matter has been already adjudicated last year in August, my lord. But the matter was kept pending, the final order. But when all are agreed by the order, this the impugn order. I think that was 1 year has been passed. I think we have to.
The matter was CAV, Lordship. Finally,
Yes.
the matter was heard and the matter was CAV, Lordship. And then, Lordship, they have filed a writ petition because of which this impugn order was passed, Lordship. So I am just praying, Lordship, a date may be fixed before the lower court and within a fixed time frame, within a period of 1 month. All these, whatever the disputes are, that may be taken on record and order may be passed, Lordship. Because there was a substantial argument also made before the court in Kolasib, Lordship. Even after that, Lordship, the trial court has kept the matter pending till January 2026, Lordship. From August till January 2026, and no order was passed, Lordship. And then this impugn order was passed, Lordship. So it is only fair, Lordship, that this matter may be relegated to the trial court and order may be passed within a period of 1 month, Lordship, the injunction application, Lordship. Because the petitioner is illegally enjoying an interim order from 5/3/2025, Lordship. It's been 1.5 years, and that is my money.
What is the
Your
interim
Lordship,
order?
I object to that.
What is the
It was-
interim order? Where is the
People
interim
find
order?
that is page number 37, Lordship. Page number 37, Lordship. This order dated 5/3/2025. Lordship will see the operative portion at page number 40.
Page
Page
number
number
40.
page number 39. From 39, Lordship may read it. Para number 6. The applicants prays for an injunction under Order 39, Rule 1 and 2 to restrain the opposite party, that is the bank, Lordship, from releasing any amount lying in their bank account or to do any activity without their knowledge and permission as it would cause them irreparable damage. The counsel for the applicant is present and makes an ad interim prayer to the opposite party not to dispose of any amount in the bank account of the applicant to any person, stating that the applicant fears that this account has been subjected to misuse and that the opposite party may undertake actions without his knowledge produces him. After hearing the counsel of the applicant, it is seen that if the contention of the applicant is correct and an unexplained action regarding the account of the applicant without proper knowledge and justification would be prejudicial to the applicant and negate the purpose of the suit. Also, considering the said prayer of ad interim as an urgent nature, this court allowed the ad interim prayer of the counsel for the applicant and direct the opposite parties to maintain status quo and not to dispose of any amount till hearing on the point of injunction or any further orders. Now, point of injunction was argued in the month of August 2025. Even then, Lordship, the final injunction order was not passed by the Honorable Court below, Lordship.
Your Lordship, that was already stated in my petitions, all the facts. Now, the order which was impugned, which we have come across under page 141, which have already been read out, Your Lordship, that in that order, a prejudice has been caused to me because the, am I audible?
What is the prejudice caused?
Your Lordship, that in the injunction petition, we have already submitted that there was a disputed amount and undisputed amount. So the disputed amount should be hard or kept in restraint till final disposals of the case. But as far as the undisputed amount is in restraint, it caused many prejudice to me, my lord. It is more than 1.5 years, which I cannot touch my account, my lord.
So therefore, we propose to dispose of, directing the civil judge to pass orders appropriately, taking into account the pleadings available before the court and the submissions,
All
both
right,
with
my lord.
regard
All
to
right.
the issues of the disputed and the undisputed amount. If according to the court, there is an undisputed amount, then we'll direct the court to permit you to utilize this amount.
My lord, my lord. If
right.
I may permit to submit one case law regarding Delhi High Court judgment, your lordship.
All right. No, what is we are only closing this matter, Mr.
My lord, my lord,
Petitioner
my
in
lord.
person.
The-
We are
yes, the
closing
Delhi High
it.
Court-
We are directing both parties to appear before the civil court. And the civil court will pass orders, because this order which you are impugning before the court is very clear that the court has not proceeded in view of the writ petition pending, which now, as per the submissions, the writ petition is closed. Writ appeal has been allowed. So the court is bound to follow the orders passed by the High Court, if it is relevant.
As far as that writ petition, disposals of the writ petition is concerned, it only confined to a challenge of the ex parte order passed by the Chennai magistrate.
But this writ appeal arises from the writ petition, isn't it?
That writ petition, yes, that writ petition is confined to the order passed by Chennai magistrate ex parte order. On the prayer of the case IO, without assigning any reason, my account has been directed to be transferred to the private respondent, respondent number 5, my lord.
All right.
My
We have
lord.
heard counsels, we'll pass orders.
My lord, my lord.
Heard, disposed.
I am obliged, my lord.
My lord, a date may be fixed, lordship, and a time frame may be given before the court below.
We'll do that. We'll take into account. Disposed.
Lordship. Highly obliged.
We'll reassemble at 2 p.m.
Daily list, item number 2.
Yes.
My lords, I appear as amicus. I'm for the appellant. It's a jail appeal, my lords, from a POCSO.
You need a paper book.
May it please your lordship. On the last day, that is 23rd July 2026, this honorable court was pleased to direct dusty service upon the respondent. In compliance with the said direction, the respondent was personally served on 31st July 2026, and an affidavit of service has also been filed before this honorable court on 3rd August 2026.
My
And
lord,
my lord,
I'll be representing the sole respondent. I had already filed my power.
You're appearing for the sole respondent.
Yes, your lordship.
Okay.
The TCR will have to be called for TCR,
TCR is to be called for.
and I will be filing my cross objection in this case.
Okay. Heard counsel for parties in terms of the earlier order dated 23/7/26. Dusty, steps by Dusty was undertaken and an affidavit of compliance has been filed. And Mr.
Victor,
Victor appears for the sole respondent.
yes, your lordship.
Sole respondent. Let the trial court records connecting to so-and-so case from such and such court be called for. Matter be listed immediately upon receipt of the trial court records.
Much obliged.
Item number 5.
Okay. May I please, Your Lordship?
Yes.
With regard to item 5, however, if I take Your Lordship to the affidavit filed by respondents 3 and 4, there are certain documents which have not been submitted.
3 and 4.
Yes, it was filed in February, I think, this year.
Okay.
Your Lordship, in para 8,
Yes.
they have referred to the minutes,
Para 8.
para 8, Your Lordship.
Of
Page
the-
4, page 4 of the affidavit, filed by respondents 3 and 4.
3 and 4.
Your Lordship, I may read this.
Yes.
With regards to statements made in para 8 of the writ petition, I say that the 2021 regulations outline core faculty promotion as senior grade and selection grade. No rules currently govern ETC principles. The petitioners were initially included in the 2017 draft faculty service rules reviewed in the 43rd SLAC/GB meeting, but were excluded via the 2021 regulations 52nd SLAC-GB meeting, which also directed drafting of unified service rules, excluding the core faculty. Restructuring was approved in the 57th SLAC/GB meeting, and the proposal was submitted to the Administrative Department for notification February 2025. Look, none of these documents have been annexed to the affidavit. So if the respondents can be directed to annex all these documents, like the 2021 regulation, the meeting minutes held on 52nd, the 52nd meeting of the SLAC GB meeting.
Who appears for the respondent, 3 and 4?
Yes, Your Lordship, I'm appearing
So,
for all the respondents, Your Lordship.
for all the respondents?
Yes, Your Lordship.
So, Mr. Malhotra points out
Yes, Your Lordship.
this para 6, para 8 of the affidavit, there are
Yes, Your
certain
Lordship.
documents, the reference of which is made, but the documents are not available.
Yes, Your Lordship.
Please bring it on record by filing additional pleadings.
Certainly, yes, Your Lordship.
Your Lordship, if I may, para 9 also, and the third last line, as per the unnotified 2024 draft rules. So even those may be included, Your Lordship, at para 9.
Why are the draft rules necessary? Now the rules have not been finalized.
Yes, Your Lordship.
Okay.
According to them, under the 2021 regulations, the petitioners are not covered. And now they're covered by the draft rules of 2024, which have still not been notified till date.
Mr. Malhotra appears for the petitioner. MS so-and-so appears for the respondent. All the respondents,
Yes, Your Lordship, all the respondents.
counsel for the petitioner submits that in the affidavit filed by respondents 3 and 4, there is an averment in para 8 and 9 with regard to the draft faculty service rules. Which were approved in the 57th SLAC/GB meeting. And the proposal has been submitted to the Administrative Department for notification in February 2025. And similarly, in para 9 of the affidavit, there is an averment that 2024 draft rules are also available. So these documents are not a part of the affidavit filed by respondent 3 and 4. So, para. Learned counsel representing respondents 3 and 4 submits that they would like to bring these documents by filing additional pleadings. They pray for how much time you'd require?
Your Lordship, if I may be allowed to, if I may be allowed 3 weeks' time, Your Lordship, to file
3
the
weeks.
necessary documents.
They pray for 3 weeks' time to bring the same on records by filing additional pleadings. Counsel for petitioner does not oppose the prayer made. Released again after 3 weeks on a date to be fixed by the next week.
If I may be given liberty to file a short reply to this affidavit.
Petitioner is also permitted to file rejoinder to such an affidavit, to the affidavits filed by respondents 3 and 4.
I'm obliged.
Much obliged, Your Lordship.
Item number 6.
Yes.
Yes, Your Lordship, I'm representing the District Collector Aizol, that is respondent number 4, and I have already submitted my affidavit in opposition.
Okay. Any rejoinder to be filed by the petitioner?
Your Lordship, I appear on behalf of my senior CGC, Ms. Irem Sangpui, for respondent 1. We will not be filing affidavit.
You're not filing.
Yes, Your Lordship.
You don't want to file.
We have not been received any instruction to file.
You're not
So-
filing it.
Yes, Your
All
Lordship.
right.
Yes, Your Lordship. I'm appearing on behalf of my senior Priscilla Thangmoya, as he is having personal difficulties.
Have you filed any rejoinders?
They have not yet filed, my lord.
All right. The respondent, district collector, has filed their affidavit,
As well as respondent 2 and 3, man.
as also respondent 2 and 3.
Yes, man.
No rejoinder has been filed by the petitioner. Counsel appearing for the petitioner submits that the arguing counsel has some personal difficulty today. Let this matter therefore be listed after 2 weeks, by which date the respondents may also file the rejoinder affidavit if so advised. Learned Counsel, Mr. So-and-so, appears on behalf of the CGC. Relist after 2 weeks on a date to be fixed by the registry.
Item number 7.
Same prayer.
Yes, yes, Your Lordship.
Same prayer.
Yes.
Anyone for the respondents? Ms. So-and-so, counsel for the petitioner, submits that the matter be taken up on some other date as the arguing counsel has some personal difficulty. From the records, it is seen that the affidavit in opposition has been filed on behalf of the state respondents 1 to 4. Accordingly, the matters be listed again after 2 weeks, by which date the petitioner may file the rejoinder affidavit if so advised. In the meantime, relist after 2 weeks on a date to be fixed by the registry.
Item number 8.
Your Lordship, I appear for my senior CGC, Ms. RM Sangpui for respondent 4, and I may pray for some more time to file affidavit.
And Your Lordship, I'm representing the state government and I'm seeking another 3 weeks' time to file my affidavit.
The counsel appearing for the CGC, representing the central government, as also the state government, submits that they be permitted 3 weeks' time to complete their instructions and file affidavit if so advised. Counsel for the petitioner does not oppose to the prayer made. Relist again after 3 weeks on a date to be fixed by the registry.
Item 10.
Yes.
Your Lordship, I appear on behalf of respondent 1 and 2. I may also pray for some more time.
Yes, Mr. Malhotra, any objections?
I have no objection, Your Honor, but the state is also there. Respondent 3 to 5.
State is relying on the CGC to pray for time. Yes, counsel for the respondents appearing, representing the union as well as also the state government renews their prayer for further time. 3 weeks' time is prayed for to enable them to complete instructions and file their affidavit. Counsel appearing for the petitioner does not object to the prayer made. Relist again after 3 weeks on a date to be fixed by the registry.
Item number 12.
Yes.
May it please, Your Lordship.
Yes.
My Lord, this bail application.
Yes.
Yes, Your Lordship, if I may pray that this matter may be passed over for today because I have some personal difficulty in attending the court personally due to the illness of my daughter. So if this matter can be passed over for today, Your Lordship.
All right. We'll have it on Wednesday.
Yes, Your Lordship. I would
Wednesday?
be very...
Wednesday is DB day, my Lord.
Oh, DB day.
Yes.
Then Thursday?
Yes.
Thursday or Friday?
I would be grateful, Your Lordship.
Thursday, my Lord.
Thursday? All right.
All right.
On a prayer made by the learned, your APP?
Yes, Your Lordship.
Learned APP, expressing personal difficulties for the today. Matter stands deferred to be listed again on Thursday.
Deeply obliged.
Mr. So-and-so appears for the writ petitioner, petitioner for the in bail application number so-and-so. Yes.
Item number 13.
Your Lordship,
Yes.
TCR has been received and paper book may be prepared at the cost of the appellant.
Sorry?
The TCR has been received and paper book may be prepared at the cost of the appellant.
Paper book required? Yes. Counsel for the appellant submits that in deference to the order dated 18/6/2026, the appeal having been admitted and the trial court records called for have been received, the registry be directed to prepare the paper book at the cost of the appellant. Where a premade is allowed, registry is directed to prepare the paper book at the earliest, is to notify the cost necessary for preparation of the paper book, and whereupon the petitioner, having upon depositing the amount, the paper book should be prepared at the earliest, list after 3 weeks.
Oblige.
Item number 14.
The counsel for respondent number 5 is from Gauhati.
Oh.
Government. It's
Okay,
the
item 2, be called up next, you want it after next week or after 2
after a
weeks?
week, after
Be called up after a week on the request made by Mr. Malhotra, counsel for the petitioner. Appellant, I think.
petitioner.
Petitioner.
I'm on that.
Good.